Welcome to 5 at 5 with Stone Law Offices. I'm attorney Brendan Bybee with 5 minutes on why not to write on your estate plan documents. Now, this is a pretty common thing that occurs where somebody will come in with their estate plan documents. They want us to take a look at them. And so we get the documents. Turns out they're original documents that they signed in the binder that they got from their attorney. And as we look through their documents, we see notes and scrawl all over the pages of their will or their trust, and all these notes on, maybe somebody's name is scratched out. This person, I don't want to get anything. They write another person's name in. I want this to go to this person instead. They may have writing all over that. Now, this can be very problematic. And the reason I'm making this video is so that you'll know, please put the pen down. If you're dealing with your actual estate plan documents, your original documents, especially when it's a will, even if you have a trust and aren't expecting that will to come into play, but also with a trust, don't write on those documents. Make a copy of it, write on the copy, or just make notes on another piece of paper, but please don't write on those documents. Now, the why shouldn't you write on these documents? Well, there's certain formalities that go into the execution of these documents so that they'll be valid and legal documents that can be upheld against any objections. And so to the extent that you interfere with that by writing on them, you may blow up your entire estate plan. Now with a will, wills have certain formalities. They're really in the package of documents that we put together when we are executing an estate plan with a client. The will has the most formalities. We go through, even though it may be a rather minor player compared to the trust that's most intended to carry the greatest amount of weight, bear the greatest burden in this estate plan, that will is a very critical thing. It's required to be understood by you, and that you affirm that before witnesses, that you're of sound mind, that you understand the document and its effects on your estate plan and how it distributes your property to the parties that you name as beneficiaries, and that these witnesses are able to sign their name saying that they know that you were competent, not under any duress or undue influence, and that you intended your estate to be distributed as described in that document. Now, like I said, that requires certain formalities. Even having witnesses with a will, I've had wills where the witnesses themselves, though they signed on there, I still had to get affidavits from them in order to do a probate on an estate because of the way that the wills were signed. It just required these additional steps to get the court to accept it, because certain formalities that would have made that a little simpler just weren't done. So when you consider that, then handwriting on that will, well, what does that do? Well, because you have to have those formalities to make that first will valid, now what you're doing is introducing another element there. And what formalities are there to that change? Now, under Nevada law, you can handwrite a will. It's called a holographic will. You might expect that there are certain complications or reasons why it's not ideal. And if you handwrite a will and you say, okay, this is what I want to have done, this is what I want to have done, this is who gets my stuff, and you sign and date that, that's called a holographic will. Now, if you miss any particular element there that the statute requires, such as, material elements are not in your own handwriting, but somebody else's or even typed, then that's not a holographic will. If you've signed it, but you haven't dated it, that's not a holographic will. So if there are changes to your will, if you've handwritten something in there, then that's what the court is going to have to do, is determine were the formalities of a will, were they met in creating these changes. And if you've just handwritten on there, likely it hasn't. And I haven't seen, maybe once, if at all, where somebody's actually done that as though it was a holographic will. They've just written notes on there and scratched things out. And so since they don't have those formalities, those changes don't have the force of a will. But even setting that aside, now it's possible that could be upheld if it had the formalities of a holographic will. but usually you're going over multiple pages, so you have to do that on every single page where that's done. But like I said, if you think about a handwritten will and the problems with that, well, it's more likely when you don't have a formal written will that's executed, prepared by an attorney and executed in their office. There's much more room for dispute over, was this really done by this person? What was their state of mind when they did it? And can this really be upheld? So again, when we come back to that, now you've got written on your perfectly valid, formally executed will, a bunch of notes and scribbles on there. Maybe there was an attempt to make those valid as a holographic will, but you've really just muddled the picture there. And in many cases, it may not just be that those changes are invalidated by the court, but they may look at that as, well, they by making these marks on here, they've really repudiated the will. They've attempted to terminate this will and revoke it, and therefore we're going to ignore the will. We're not going to admit it to probate, and we're going to deal with this as an intestate estate, which is what happens when somebody dies without any will. Then there's no will to govern that, and it's administered under the statutes. If you've gone to the trouble of creating a formal will, then taking that step of writing on that will and potentially invalidating the entire thing, or at a minimum, invalidating the changes that you intended to make instead of getting those done correctly. Well, in any case, you're going to have it. It's not going to go the way that you wanted it. And in other cases, in many cases, it may be the entire thing is invalidated. Nothing goes as you intended it, as you planned, and it's a much more complicated affair. Clearly, if there are certain people that are advantaged by one take on it versus the other, then that just raises more room for there being disputes and anger and expense. Anytime something is not clear, you've got extra expense in the courts, extra time, and extra room for fights. So again, I urge you, if you have notes that you want to make about your estate plan, if you're contemplating changes and you're thinking, let me write it here right by where this is at so I know where to find it, don't do it. Make a copy, do it on the copy, write it on another piece of paper and put it in there, even a sticky note, as long as you are not marking up the actual pages of your original documents, because we don't want to have to deal with an intestate estate, an additional frustration with your estate and your heirs, administering it with that kind of confusion. We would much rather have something done correctly in the first place, and then help shepherd a very simple, straightforward administration done after the fact, where your beneficiaries are not frustrated, and where they get to keep more of the money instead of at the expense of additional court action due to that careless mistake. If you're one of our clients, you've heard this spiel before when you came in and signed the documents. But regardless, if you have done something like that to your documents, come see us. Let's get that thing straightened out so that your intentions are going to be upheld, and so a split second error in judgment does not entirely upset your estate planning.